Are there different types of appeals for tax audits? Attorney William Kunofsky explains that. There are different types of appeals. Appeals is a separate branch of the IRS that is actually independent of audit. Of course, the appeals conferees are typically experienced auditors, so they are aware of audit techniques and highly skilled in tax law. You must write a protest letter saying that you disagree with the tax liability that was determined by the auditor and why you are attesting any penalties you have. You must provide legal grounds for your disagreement as well as the issue of documentation. It must be filed on time. Typically, appeals are not there for the purpose of re-auditing the tax return. They are interested in the specific findings that you can document a business purpose or that the law was applied incorrectly or that they applied the wrong law completely. Appeals have settlement authority based upon litigation risk as well as equitable arguments. They can settle the case at their level. If a settlement is not reached with appeals, then the taxpayer has choices as to how they would litigate the case. There are actually 4 courts that deal with tax liability. The typical case goes to the United States Tax Court because you do not have to pay the tax prior to the hearing in the tax court. However, interest and penalties can continue to grow. You can also go to the United States District Court or the United States Court of Claims, but you have to sue for a refund, which means you will have to pay first. If somebody is in financial shape, the United States Bankruptcy Court has the ability to determine a tax liability. So there are 4 courts, and you can then go up to appeals courts and United States Supreme Court. It gets very expensive to go all that way, but still, you do have the opportunity to have independent review of an IRS decision. For a free phone consultation, contact Attorney William Kunofsky in Dallas, Texas at 214-369-1040 or visit his website at www.debtfighters.com.